Industry voice, environmental self-disclosure as a strategic risk tool in M&A. Environmental self-disclosure is often discussed in terms of regulatory compliance or enforcement. In modern transactions, however, it has evolved into a strategic risk management mechanism that can materially influence valuation, indemnity structures, escrow sizing, post-closing integration planning, and ultimately whether leadership views a transaction as financeable, executable, and worth pursuing. In mergers, acquisitions, divestitures, and financing involving regulated assets, environmental non-compliance is rarely clear-cut. Buyers frequently inherit latent exposure through expired permits, undocumented releases, monitoring or reporting failures, and historical operational practices that no longer align with current regulatory expectations. How these issues are identified, evaluated, escalated, and disclosed determines whether they remain manageable business risks or develop into material regulatory, financial, and reputational exposure. At the federal level, the U.S. Environmental Protection Agency's incentives for self-policing, discovery, disclosure, correction, and prevention of violations, EPA audit policy, provides the primary pathway for mitigating penalties and restraining criminal referrals. Complementing that regime, the Department of Justice's Environmental Crimes Section issued its own revised corporate enforcement and voluntary self-disclosure policy on March 23, 2026, which governs potential criminal exposure arising from corporate actions, including violations discovered during diligence or in post-closing. This article explains how these policy frameworks operate in the context of mergers and acquisitions, highlights the decision points that most materially influence executive decision-making, and provides examples of state-level distinctions that can preserve or erode value depending on how they are understood and addressed. The EPA audit policy in M&A, turning discovered violations into deal certainty. EPA's civil penalty model ordinarily includes two components: gravity-based penalties, which reflect the seriousness of the violation, and economic benefit penalties, designed to recover any financial advantage gained through non-compliance. Under the audit policy, companies may obtain a complete waiver of gravity-based penalties if they meet all 9 eligibility conditions. Even when a violation is not uncovered through a formal environmental audit, EPA can still waive up to 75% of gravity-based penalties. Although EPA generally reserves the right to recover economic benefit penalties, the agency may waive them when the economic benefit is insignificant. In an M&A context, this penalty mitigation framework directly influences how leadership evaluates indemnity exposure, purchase price adjustments, escrow sizing, post-closing remediation budgets, and the overall economics of the transaction. When violations can be disclosed and resolved under the audit policy, either before closing or during early post-closing integration, executive teams are often better positioned to convert open-ended environmental exposure into bounded, quantifiable risk that can be incorporated into valuation, integration, and capital planning decisions. The 9 conditions through a deal lens: timing, independence, and control. Among the 9 eligibility conditions in the audit policy, 3 are especially significant in transactions: voluntariness, timing, and independence from government action. The timing element is often the most consequential. EPA requires companies to disclose violations within 21 days of discovery, a clock that frequently begins running during environmental due diligence. Discovery may occur during pre-closing site assessments, post-closing compliance audits, or operational integration activities, but care should be taken to meet the requirements for systematic discovery to preserve the maximum forgiveness. Leadership teams should assume that once a violation is sufficiently understood to be recognized as such, the disclosure clock may already be running, regardless of whether the transaction has closed. Maintaining independence from government action is equally important. To preserve eligibility under the audit policy, disclosure must occur before the company becomes aware of government inspections, citizen suits, whistleblower complaints, or information requests. In transactions involving distressed assets or facilities already on a regulator's radar, this requirement may necessitate accelerated post-closing review and remediation planning to preserve eligibility and reduce downside risk. Criminal exposure in transactions, coordinating EPA and DOJ strategy. Environmental criminal exposure is among the most disruptive risks facing executive leadership in transactions involving regulated assets, particularly for private equity sponsors, lenders, and public companies. EPA's audit policy states that the agency will generally refrain from recommending criminal prosecution where violations are voluntarily discovered, disclosed, and corrected in good faith. Although DOJ is not bound by EPA's position, this significantly reduces referral risk. DOJ's own corporate enforcement and voluntary self-disclosure policy, issued on March 23, 2026, provides additional clarity. Under that policy, DOJ will not seek a guilty plea where a company voluntarily self-discloses, fully cooperates, and appropriately remediates the misconduct, absent aggravating factors. Notably, the DOJ policy expressly extends its benefits only if the company had no pre-existing obligation to disclose the misconduct to the DOJ, and the disclosure occurs prior to an imminent threat of disclosure or government investigation. For this reason, leadership should ensure that EPA and DOJ strategy is aligned early across transaction, compliance, and operational work streams. Engaging EPA without considering DOJ implications may leave criminal exposure unresolved, while focusing on DOJ alone may undermine opportunities for civil penalty mitigation. New owner and post-acquisition audits, federal clean slate mechanisms. Recognizing that strict enforcement against inherited violations could discourage remediation, EPA developed the interim approach to applying the audit policy to new owners, which provides enhanced penalty mitigation for violations discovered after acquisition, offers flexibility in disclosure timing, and acknowledges that buyers may have had limited access to the facility before closing. These features make the policy particularly valuable for leadership evaluating carve-outs, distressed transactions, cross-border acquisitions, and deals involving legacy industrial operations where inherited risk can otherwise impair value. State audit privilege and immunity laws, deal-defining differences. State law often determines whether environmental audit findings remain protected internal diligence materials or become discoverable information that can increase transaction and litigation risk. For example, Texas's Environmental Health and Safety Audit Privilege Act is considered one of the strongest frameworks in the country. It provides protections that can materially improve how leadership manages diligence, disclosure, inherited liabilities, and post-acquisition remediation. Colorado's regime provides both privilege and penalty immunity, but preserves the state's inspection and injunctive authority, making timely correction especially important for leadership seeking to limit inherited exposure. Ohio statute, Ohio Rev Code 33745.71-2, provides civil penalty immunity, excluding economic benefit recovery, while requiring highly structured and formalized disclosure. By contrast, Illinois repealed its audit privilege law in 2005, leaving audit findings unprotected by statute and increasing the importance of disciplined internal review, escalation, and disclosure governance. RWI as a complement to environmental self-disclosure representations and warranties insurance, has become common in deals involving regulated assets, but leadership should recognize that it primarily responds to breaches of representation rather than regulatory liability itself. RWI coverage generally applies only if the seller makes an environmental representation. That representation is breached, and the breach results in a covered loss as defined by the policy. Most RWI policies exclude known environmental conditions, matters disclosed in schedules, issues subject to specific indemnities, and often fines and penalties. These exclusions create an important strategic intersection with self-disclosure policy. Once a violation is disclosed to regulators, it becomes a known issue and is generally excluded from RWI coverage. Conversely, withholding disclosure may preserve theoretical insurance coverage but also increase regulatory enforcement risk and compromise the benefits available under EPA and DOJ policies. In practice, RWI is most useful for unknown historical risks, not known non-compliance that leadership expects to address after closing. RWI is therefore most effective when paired with regulatory mitigation strategies, contractual risk allocation, and, where appropriate, pollution legal liability (PLL) insurance. Carriers place significant weight on the quality of environmental due diligence, including the robustness of Phase 1 environmental site assessments, compliance audits, and environmental management system reviews. In recent years, the RWI market has tightened around PFAS, emerging contaminants, and high-risk industrial sectors, making supplemental PLL policies more common in transactions involving significant environmental exposure. For corporate leaders, it is important to leverage RWI, PLL, and other insurance products in conjunction with other risk mitigation strategies. Privilege management in deals. Federal law does not recognize a general environmental audit privilege, and EPA has repeatedly clarified that the audit policy does not create evidentiary protections. Disclosure of protected state audit materials to federal regulators may also waive privilege under state law, and several states have narrowed their privilege statutes in response to EPA concerns. For executive leadership, this makes disciplined management of sensitive diligence findings, internal escalation pathways, and disclosure sequencing essential to preserving flexibility and reducing unnecessary exposure. Make sure the General Counsel's office is tightly connected to your diligence process to maximize the available protections. Environmental risk in transactions is rarely eliminated. Instead, it must be assessed, priced, allocated, and strategically managed by leadership. Effective executive oversight requires integrating disclosure planning directly into diligence, aligning EPA and DOJ engagement early, understanding how state privilege regimes may affect risk, assuming disclosure decisions cannot be undone, and ensuring that environmental audits are treated as strategic decision support tools rather than narrow technical exercises. A clear understanding of these federal and state policy frameworks has become essential to protecting value, reducing uncertainty, and improving transaction outcomes in regulated industries. John Pizarnik is an executive vice president and practice lead in J.S. Held's environmental, health, and safety practice. With over 30 years of experience, John provides consulting and expert services for heavy industry and law firms throughout the country with a focus on oil and gas, energy, and public utilities, including serving as an expert witness in arbitration proceedings and in state and federal courts. He has extensive experience evaluating risk associated with potential and ongoing compliance obligations, developing strategies around those obligations, and working to implement a client-focused compliance strategy. Mr. Pizarnik has appointments as an independent monitor through EPA's suspension and debarment program. John routinely supports clients in a forward-facing role for rulemaking and legislative issues involving energy, environmental, oil and gas, and related issues.